So it's just do pass. So your bill is out. Thank you. That's what you tell me. Okay. So next our item is our item 2, AB 60. Ms. Gonzalez.
In 2013, we passed and the governor signed AB 1159 as a way to prevent immigration attorneys, consultants, and notarios from scamming people into paying money prior to the enactment of immigration reform acts passed by Congress. That proved to be a smart bill. AB 60 is a consumer protection measure which will extend the existing protections to 1.5 million Californians that are eligible to seek relief under the President's executive actions. The injunction made by a federal judge in Texas creates a large window of opportunity for predatory practices in our state. We believe it's unethical practice to charge consumers for a program that has not been formally implemented and may never be so, unfortunately. In fact, there was a reported case in my district of this already happening, a woman coming forward. She had been charged already to get in line for an executive order for DAPA, which we know does not currently exist in a form that could be achieved. This is one of many other cases throughout California in which a vulnerable population is being targeted by malicious and unscrupulous attorneys, consultants, and notarios. We need to put an end to these predatory practices occurring in our state. Today we have testimony from Lema Murtaza from the Asian Americans Advancing Justice and Chris Castrillo from the LA City Attorney.
Thank you. Your witnesses in support, please.
On behalf of Asian Americans Advancing Justice Los Angeles, the largest civil rights and legal service organization serving Asian Americans, Native Hawaiians, and Pacific Islander communities, I am here today to support AB 60. AB 60 will provide protection to immigrant populations who have been targeted of unscrupulous attorneys and immigration preparers and notary services, more commonly known as notarios. AB 60 will strengthen current laws under AB 1159 and will ensure that those who apply for the President's executive action have protection against immigration and fraud. Advancing Justice has seen too often instances of clients who have been scammed by unscrupulous attorneys, immigration preparers, and notaries. This is why AB 60 is a bill we support. Thank you.
Thank you. Next witness, please. Next witness.
John Lovell, California College and University Police Chiefs Association. We protect about 3 million people in California, and among the people we protect are cohorts of people who have been victimized by these processes. This is a good sense bill. We strongly support it.
Thank you.
Thank you. Your next witness, please.
Christopher Castrillo on behalf of Los Angeles Mayor Eric Garcetti and Los Angeles City Attorney Mike Fuhrer in support of this legislation. We feel that this will close a loophole and apply important safeguards and consumer protections for immigrants seeking services under the current executive action. We appreciate Assemblymember Gonzalez's effort and appreciate her leadership on this important issue. Thank you.
Thank you. Next witness.
Michael Young, California Labor Federation, also here in support.
Thank you.
Joseph Villela on behalf of CHIRLA, the Coalition for Human Immigrant Rights in Los Angeles. I'd like to thank the Assemblywoman for continuing their efforts to protect undocumented immigrants and will support this bill. Thank you.
Thank you. Any other witnesses in support? Please.
Good morning, Mr. Chair and members. Sandra Palacios with the California Catholic Conference is also in strong support. Thank you.
Thank you.
Good morning, Renee Bayardo, SEIU, California, also in support.
Thank you. Any other witness in support? Right. Are there witnesses in opposition? Yes. Please come forward. You can come to the table if you like.
Okay, great. That would be easier. Good morning. My name is Heather Poole. I'm the author of the one opposition letter that you received with this bill. I am the chair of the American Immigration Lawyers Association Southern California chapter, which is the largest chapter in the state of California. It consists of about 1,200 immigration lawyers. We do have the support of the other 3 remaining immigration attorney chapters in California, and they have all written documentation that you should be receiving in your offices shortly. We do support all these organizations that are up here on one central theme. We are all on the same side here. We don't want anybody to be defrauded. We don't want anybody to be taken advantage of. It's an epidemic in immigration. Okay, notarios, immigration consultants, they are known for setting up shop in ethnic communities, taking cash, no contracts, then either filing the wrong thing or filing nothing at all and then disappearing. People are either put in removal because the wrong thing has been filed, or they're placed in removal because nothing has been filed. And by the time they get to us as immigration attorneys, the damage is so severe that many times we can do nothing to stop the inevitable. So I have drafted a few comments so you understand why we are opposed to this. We are just as concerned about people being taken advantage of, but this bill harms the very population that you are trying to protect, undocumented immigrants. It literally steers them away from immigration attorneys, the people who are most able and know the law, who are able to advise them. And further, AB 60 is a waste of legislative resources. AB 60 prohibits licensed attorneys in California from accepting payment for specified legal services. We agree, we shouldn't be charging for something that doesn't exist in the law yet. However, there's too much vague and unknown language in this that will really preempt the kind of supportive and background services that we provide as part of our daily practice as immigration attorneys that's created by this law because it is overly vague. This also seems overkill because there are many rules that already govern attorneys. The legislature should not be stepping on the state bar. The State Bar of California regulates what we do, and we are subject to sanctions. We are subject to civil and criminal liability. There are existing business and professional code, also already has existing law that regulates our practice. We are concerned that AB 60 sends a clear and inescapable message to the general public that immigration attorneys cannot be trusted, which sets a dangerous precedent, guiding this very vulnerable population away from the very people who could help them the most. By pushing immigrants away from attorneys, you push them in the direction of these document preparers and notarios. Have no contract in place. As you know, as state California attorneys, anything over $1,000, we have to have a contract in place. This protects our clients. There's no such thing for notarios and immigration document preparers. We are the only attorneys subject to this extra regulation, so it definitely does give a point of view to the general public that they should caution when working with an immigration attorney. The bill tells the general public that an extra measure of protection is needed in the law, which implies that immigration attorneys are sly enough to somehow avoid sanction and prosecution with the state bar and the state's existing criminal and civil codes, because those laws apparently are not good enough. This bill lumps us with those who typically defraud and harm an immigrant, notaries, consultants, and immigration document preparers. Again, we believe this bill is misguided in its effort to further regulate attorneys. But our biggest concern is that the bill is overly broad. I saw the changed language this morning that further excluded from immigration services definition those services that have quote-unquote independent value outside of immigration reform measures. But even this term is overly vague. How do you define what is independent value? It really goes to the heart of not knowing what we do as immigration attorneys. When someone walks into our office and asks for a consultation, they don't say, okay, I want to file for a provisional waiver. I want DACA. We look at their facts. We look at their background. We look at what they've filed. We look at their criminal history, their family history, their immigration entry history. And we try to find a route for this person. But because we have no way to assess what an independent value is to any background services, it creates a chilling effect on attorneys to be able to run anything. We don't know what isn't covered under this law and what is not. There's no way to make this black and white. So unfortunately, in this time now, under President Obama's administration, more immigrants have been deported than any other administration, Republican or Democrat. They need immigration attorneys who know what they're doing, and we have very few of us who are still around, and we are deterring good ones from entering the profession when we keep putting regulation on top of regulation when there already are mechanisms in place. We urge you to take a second look at this law. It has good intent, but it's not for the best of the population.
Thank you. Any other witnesses in opposition? All right, seeing none, I'll bring it back to the committee for questions. Mr. Alejo.
Thank you very much. This issue, I think we had a lot of discussion, a lot of support. In fact, the governor signed the last year's bill, and I don't remember AILA, a respected organization like AILA, weighing in. in the fashion that you are today. I think you're taking the wrong strategic approach. Rather than opposing, you should be saying support with potential amendments to work with the author, who's very supportive, has been one of the biggest champions for immigrant communities here in Sacramento. So I think Ayla is taking the wrong approach. I started my legal career out as a research assistant at the UC Davis School of Law Immigration Clinic, working on a lot of these cases. So this is something that's very dear to me as an attorney and as somebody who practiced in immigration law. But I think the reality is that this bill is not intended and will not impact any immigration attorney who is following the law. We all know in every profession, not just in every profession, and the legislature weighs in on rules on attorneys through this committee, and we have the Business and Profession Committee. We weigh in a lot of different professions. We legislate, we set those codes that you referenced, the BMP code. We, the legislature, set rules for every profession imaginable in the state of California. And we're in that realm of doing the same when it comes to the practice of immigration law. Our intent is to protect immigrant communities because there is those bad ones, and that's what these rules are intended for. Those who do not follow the law, the scofflaws, who do take advantage of communities. I've seen them. You just have to go to the state bar and look at the discipline procedures on immigration attorneys. You'll find those cases where people have taken advantage of the most vulnerable, exploit the undocumented, tell them they could deliver services and outcomes that are not real. And in fact, many of those cases, they put those immigrants into a worse situation, into deportation, removal proceedings. So for me, that's very concerning. But we have a very real situation where immigration reform is being contemplated, debated at the national level. Unfortunately, a federal judge, an activist federal judge, took a wrong decision against the governor's DACA and DAPA plan, not under the constitutionality, but on a procedural argument of the Administrative Procedures Act. I think that was misguided. But unfortunately, you know, there was some forum shopping where they filed this case in that particular federal district court, but we'll hope that the outcome changes as it proceeds on appeal. But nonetheless, I think Ayla's Southern California chapter is misguided in taking this strategy with this author rather than working on trying to provide greater clarity. The problem is real. Any person who's practiced immigration law understands those attorneys are out there. In fact, when I talk to immigrant communities, often I only have a smaller pool of attorneys that I trust that are competent, that will do the right job, that I know will not take a disadvantage. I don't refer them to anybody. I only have a few that I can really trust, that I'm confident that they will look after the interest of immigrant communities. And I think any attorney in that area would say the same in their respective areas. There's a lot of immigration attorneys. A lot of them are not good. There's some that are very good. And I think that we have to do our job here to safeguard the interests of the most vulnerable in our state. And I think this bill carries out that goal. So I would hope and urge Ayla, Southern California chapter, to rethink your strategy, because I think you're making a mistake with the approach that you just articulated.
Mr. Chu.
Thank you, Mr. Chair. Like Mr. Alejo, in a past life, I practiced as a civil rights attorney representing immigrants, and certainly from my experience, we've seen an overwhelming number of these cases of notario fraud, consumer fraud of the highest nature from folks who purport to be providing immigrant legal services. And I have a great deal of respect for Ayla and its perspective. I just respectfully disagree today. I think that if we do not establish very clear rules in this area, certainly what we've seen in recent months and years throughout the state of California, and certainly in my district, is an overwhelming number of immigrants who are confused as to who to go to, and we have to ensure a bright line set of distinctions. And I think it actually undermines the ability of those immigration attorneys that are doing the right thing. So I'm happy to support this bill, and I would also be happy to be added as a co-author.
Thank you.
Any other comments? Mr. Gallagher?
Yeah, as I was stating earlier, I think the current status of our immigration policy creates an environment where undocumented persons are being taken advantage of. And this is another area where that's occurring. And I think actually the president's executive orders actually make it worse because they are a very questionable constitutional. It's very questionable that he has the constitutional authority to do so. Now those orders have been enjoined, and in the meantime, there's this gray area of, can people apply for this or not? and it appears the answer is no right now. And so, but my question here for Ayla is twofold. I think the bill is actually pretty clear. It says that if you can't take advance funds to get relief under these acts or under some something that will pass in the future, you can't get funds for that. So, my question for you would be, where would an immigration law attorney at this point be actually taking advance funds for something that's not law yet? I don't think that even happens, but enlighten me as to where they would even need to collect funds for something along those lines. And then secondly, it also is very clear that this would not prevent an immigration law attorney from doing work that would assist a client in preventing removal from the United States, which most of the activity, as I understand it, is going through the current processes to help prevent, in some cases, deportation. That's where a lot of the services are. This seems to protect that kind of activity under some current law or current relief that's available, but just says that you can't collect monies and try to offer services for things that aren't law yet.
Oh, I completely agree with you, and so is Ayla. We don't think our attorneys should be able to go ahead and ask for retainer for DAPA or extension of DACA relief. That's not our position.
Well, isn't that all this bill says?
No. Our position is the vagueness of all the supporting services, the background checks, the FOIAs, the Freedom of Information Act requests, so we can get copies of client files. We can do post-conviction relief. It's too vague and overly broad and not defined as to where that line is. There is no bright line as to when we can stop. That's our main concern, is that this bill, the portion of supportive services, processes in support that may affect reform, in our practice, that could be lots of different things. So there's no way to stop. Where does actually supporting reform start, and where does what we usually do to try to figure out an option for a client stop?
But see, that's where I don't understand your argument, because you could do all those things, FOIA requests, background fingerprinting, and if that's solely for the purpose of finding a way, right, under the current processes to avoid removal, this language right here would protect you, because it says, such as assisting a client in preventing removal from the United States. So if all of those things that you're talking about are done for that specific purpose, wouldn't that clearly be permitted under this proposed bill?
It's not clearly permitted. It's overly vague. We don't know what services are included and how you, as the new language came out, how you determine what has independent value in what kind of service that you're using that may or may not touch on reform as well. So that's why it creates a chilling effect. Attorneys don't know what they can charge, what they can look into, if it's going to potentially affect a DAPA or a DACA eligibility. So we would first ask that, since this new language just added, that Ms. Gonzalez's office give us further definition of what independent value actually means and how she determines what those services are.
Can I respond? Are there more questions first?
Yeah, there's more questions,
Okay.
and I'll let you respond in a minute, Mr. Chow.
In fact, my questions are very similar to Mr. Gallagher's, and the scenario that I have for you, the representative from AILA, when a client comes into your office, don't you basically, when you interview the client, don't you get an assessment of exactly what the client wants? For example, whether that person needs an adjustment of status or deportation or otherwise. So all the work that you do subsequent to that would be geared toward that particular petition. For example, in the case of a removal or adjustment of status, and everything that you do would be geared toward that. So if that law has already been passed, then you are allowed to collect fees in advance. But if it relates to, let's say, either DAPA or DACA or whichever, the law has, in which case the law has not been passed, and you're not allowed to collect the fees upfront. So I don't see the confusion there. Obviously you need to do background check and all that, but the ultimate goal, whether it is removal or adjustment of status, that will basically allow you that discretion.
Do we disagree that that is not clear, that the alternate supporting processes and supportive reform?
The term that you're debating is whether or not the term independent value is confusing or vague or nebulous or whatever. But I don't think it is, because if you think that term is used to describe, let's say, adjustment of status, then you're allowed to collect fees in advance. So I just don't see,
I think that there's a misunderstanding of what we do as immigration attorneys. When someone comes into our office, they may think that, let's say, they need a 601 waiver. They may think they need adjustment of status, but they're not the immigration attorney. They don't necessarily realize that we need to get their background checked out. We need to get their FOIA to get a full copy of the records because the notario didn't keep anything.
That's the point. But during the interview process, don't you get all the facts? The immigration attorney will determine exactly what the client will need based on the facts stated.
Yes, we need to be able to do all those things, but if they are related to DAPA or DACA relief, then we feel that we are barred from doing so.
All right, thank you. And I think from the legislature's standpoint, unless and until Congress steps up and asks on a national basis, we in California feeling like we're having to kind of close ranks and do what we can with respect to this population. It's a very, very vulnerable population. And yes, the bar regulates attorneys, but this legislature has been very clear that we are going to do what we need to do to look out for that population as it comes in, because it's a particularly vulnerable population, and regardless of who commits acts against them, this legislature has been pretty clear so far. We want to be in support of them. So this is, I feel, a very appropriate step for this legislature to do. That's why my recommendation with the amendments is to pass out of this committee. And Ms. Gonzalez, I want to make sure that you are taking the amendments that...
I am taking the amendments, obviously, in the language we're debating here.
Yes.
Yes.
Yeah. So please, you may close and you may address the concerns.
Thank you. It's disheartening for me as somebody whose community relies heavily on AILA attorneys, on good immigration attorneys. But unfortunately, not every immigration attorney is a good one. Not every one of them cares about the vulnerable population that they're serving. And we had these exact same fights with AILA over 1159. And it's amazing to me because what we were afraid of is that Congress wouldn't act, and that things that happen in my district, and I'm sure some of yours, billboards that go up, that the billboards from an attorney who say on the billboard they're an AILA attorney and say get in line first for Immigration Reform Act services. Those billboards came down the day after the governor signed 1159. All right? And then it proved to be true. Unfortunately, Immigration Reform Acts never passed. So there had been people who had gone to an attorney, paid them money for a service that they were never going to get anything back from. That's unfair. And we know as a vulnerable population, as I always say, having come from a mixed status family, we have family members, we have community members who will do anything to try to get legalized status. They will give money, they will give cash. And we have some attorneys who will take advantage of that, quite frankly. So all this does is say the same thing we said last time. Look, until there's something to sign up for, you cannot take the money of an immigrant who believes that they are qualified, who's going in to apply for DAPA and DACA. This is not hypothetical. It's amazing to me that the day after the president made his announcement on TV, in our newspapers were advertisements saying get in line for DACA and DAPA from attorneys. And we were saying, how can this be possible? Didn't we pass a law? Well, there was a loophole because we said it was an act of Congress, not an executive order. So I'm sorry that there are unscrupulous attorneys. I am. As an attorney, that pains me. Quite frankly, you don't even have to know immigration law to be an immigration attorney. That's another issue altogether. But because they exist, we have to do what we can to ensure that a vulnerable population who may or may not ever be able to apply for these services do not just give their money to somebody, hard-earned money, and never get anything back. That's all we're asking. And those great attorneys, and a vast majority of AILA attorneys are really good, very ethical attorneys, don't need to worry about anything. They need to just follow the law. So we have made sure with the amendments, I think, to ensure that legal services with any independent value, and that includes preventing removal, can continue. Obviously, we want that to happen. We just don't want people to advertise and to take money for something that is not in place. And unfortunately, and we can have disagreements on this, may never be in place. So I respectfully ask for your aye vote.
Thank you. The motion I'm looking for is do pass as amended to appropriations, and note that we are adding an urgency clause at this point.
Second.
So we do have a motion and a second. Mr. Gallagher.
Mr. Chairman, just a quick kind of language question. I see in the amendments from the committee that we have this subpart D that talks about any relief offered under any executive action announced or executive order issued. I'm wondering if it might be better, and I'm just putting it to the committee, to just use that language rather than specifically calling out DACA and DAPA, because down the road, DAPA may actually be, ruled unconstitutional at some point. It may not even be in existence, and we'll have this in our code. Whereas if we just have this broad language that says, look, any executive order that hasn't been implemented yet, we sort of already cover our bases and don't have these specific references to executive orders that may or may not exist in the future.
Well, I was just wanting to make sure that I think that section is actually inclusive, and the specificity of what we're talking about, because we're closing literally that gap where we had previously looked at what was coming out of Congress. Now there's an executive order. I think the intent here is to ensure that everything done to date and everything that might be done, and try to be inclusive in this language, is the subject matter of what we're talking about here. So I'm not sure that that's necessarily helpful. I mean, this was pretty carefully worked through to ensure that we were as inclusive as we possibly could be. Okay, so we do have a motion and a second, and again, we're do pass as amended to appropriations and adding an urgency clause. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Aye. Wagner, aye. Alejo?
Aye.
Alejo, aye. Chow?
Aye.
Chow, aye. Chu?
Aye.
Chu, aye. Gallagher?
Aye.
Gallagher, aye. Garcia? Holden?
Aye.
Holden, aye. Mainshine?
Aye.
Mainshine, aye. O'Donnell?
Aye.
O'Donnell, aye.
Your bill is out. Thank you. All right, I am now going to pass the gavel over because we're going to do item number 3, AB 87, which is mine. Mr. Wagner.
Thanks, Chairman.
Item AB 87, you may proceed when you're ready.
Mr. Vice Chair and committee members, last session, a bill was brought to public safety that dealt with peremptory challenges. And one of the questions that came out of that, or the proponents of that bill, one of their arguments was that using peremptory challenges, because the law wasn't necessarily clear, could be used against the transgender community, either because there was a bias against a person who is transgender potentially serving on that jury, or if the defendant or a person being accused was transgender, that it's a mechanism to remove a transgender person from the jury. That was being used as an argument in favor of changing peremptory challenges. And I'm not talking about that bill or that relationship with peremptory challenges, but I thought at the time, well, that is just wrong. To allow anyone to use as a peremptory challenge at heart a discriminatory act is something that California law should be very clear about. So this bill is to close that gap, is to ensure that no one can use, an attorney using the peremptory challenge provisions cannot discriminate, cannot show bias against someone on a jury who is transgender. This is consistent with California law in many other areas. It just was clear to me that this was something that we needed to address in California law now, so that someone who is transgender wanting to serve on a jury is not discriminated against through that process. That's what this bill is, and I have Mr. Baker from the ACLU speaking in support.
Baker, welcome back.
Good morning, Mr. Chair and members. I'm thankful for the author for this bill, provide some helpful clarity on this important area for counsel, courts, and jurors. I think it's consistent with existing law, and we're very supportive.
Thank you.
Move the
Additional
bill.
Bill's been moved. Is there a second?
Second.
All right. Additional witnesses in support? All right. Seeing none, any witnesses in opposition? All right. Again, seeing none, let's bring it back to the committee. Questions from the committee? All right, I'll bite. Is there a problem? I mean, anecdotally, have we heard of people being excluded from jury service on this basis, or are we just being proactive here?
I was told by judges who were proponents of the peremptory challenge bill that this is a real issue. I was not given, I asked for and was not given any specifics, but I took that seriously enough to think that if the judges are saying that that's an issue that they see or are afraid of in their courtrooms, that we should make sure that it's not going to happen.
Okay. Does the ACLU have any numbers or statistics to help?
We don't, Mr. Chair. But I have also been informed that this is an issue that is a real-life problem for folks.
All right. Additional questions or comments? All right. The bill has been moved and seconded. Madam Secretary, call roll.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo? Chow? Chow, aye. Chu?
Aye.
Chu, aye. Gallagher?
No.
Gallagher, no. Garcia? Holden? Holden, aye. Mainshine? Mainshine, aye. O'Donnell?
The bill is out. Congratulations.
Thank you. All right, that concludes the business on our file. I'm going to hold the roll open for a bit so that folks can add on. I believe everything was out, so if you'd like to add on, this is your opportunity. Thank you to all the authors and witnesses who came before us today. We're off to a rolling start. Welcome to all the committee members and new committee members to Judiciary. This is just a glimpse into our world for the next 2 years, so thank you all.